Abusia Michel na misanso emu akwa abasonko so emfa emra eye be media GH so abusia ade Ghana Bar Association ede nsem bi ede aba abontani na efa eye Godfred Dame ho na abusia we die ma mekasa anwa me ma mekasa anye tenten pese yekọ ni kwoti nsem no manchire mu ne esi ya no nti ama Ghana Bar Association atene eye hardly on eye Godfred Dame na se wi na so ho adwenche bi abomade na ya kire ya adwena be hye no so e de amen say hard so ye be media GH so busan for say ene dedicate on to channel so ye be so subscribe be like na wa bo aso abo a notification bell so for more podcast update ye tie nsem aba to justice ya emra ye da se.
They have a different constitution. But they don't have in-camera procedure. Yes, exactly. We are dealing with the constitution. We have a unique constitution. So don't bring the American proposition.
But they are stronger than us.
I am saying that when the Ghana Bar Association sued the Attorney General in respect to court speaking through his Lordship Justice Pegan, and let me conclude. He said, it will be a sad day for this country if this court were to grant the request of the Plaintiff Association and start removing our judges in open courts, contrary to the provisions made in the Constitution for the purpose. So, Senior, I know your views are usually very wild. And I think that my senior needs constitutional restraint.
I want the nation to move quickly.
Thank you. Yes, there's one position that advances good governance, and that's what Lawyer Matikbebo is espousing about the Constitution now responding to the current times and the demands of citizens. Because maybe at the time this Constitution was put together, the framers had something in mind. That's why I indicate that this provision certainly couldn't have been put there in oblivion. And Lawyer Dujiti Tamaklo clearly espouses the reasoning behind this in-camera provision in the Constitution.
Lordship Justice Bennett said, look, there's a reason for the in-camera proceedings. And that policy rationale is that it may well happen that a superior court judge or anybody who is a subject of Article 146 proceedings may come out clean. But you know how we lawyers will do cross-examination. Like we say, cross-examination is at large.
Yes.
You may end up going to ask some questions that will raise issues here and there. You can't control a lawyer when he's doing cross-examination. Actually, so once you get to the point where it becomes very clear that some things may come out that may destroy a person who goes through such a proceeding, we are not wiser than the framers of the Constitution. No. Well, for a minute, let us not assume that when the people went to the polls and said, this is the Constitution that we want, excuse my language, there were people without foresight. No. That provision is a safeguard to protect the integrity of the process itself, the individuals, and their dignity.
Well, Amadou says the society has moved on.
No, I beg.
Maybe the intent behind that then may not necessarily be responding to the exigencies of the time. Because of the demand for transparency and good governance. Transparency,
good governance itself has a limit. You can't be transparent in everything, and he's here. the day this man becomes the president of the Republic of Ghana, he will have his cabinet. Maybe the next time we'll advocate for cabinet meeting at Makola.
You see the exception to rubbish the argument.
Oh no, I'm pleading with you, Senior. Because even in democratic societies, thrones and nations are preserved by secrets. It's a common belief. Globally, thrones and nations are preserved by secrets. It's not everything you do. And that is why if the president wants to have his cabinet, he doesn't do it in the public. The Constitution and its framers would have said so. Now, what we all need to understand, with the greatest respect, is this claim, interestingly enough, in Relief 1, and I've seen it, is that if you can project relief
let's
one.
go to the first relief that the
Relief
Chief
one.
Justice is
I will be
seeking.
glad this.
Relief one is a declaration that upon a true and proper interpretation of Articles 17.1 and 2, 19.3 and 14, 1467, 1467 and 8, 2811 and 2951 of the Constitution, a Chief Justice has the right to.
Now this is where it gets possibly provocative.
A public hearing in proceedings before a committee appointed by the President.
That view provokes the 1992 Constitution.
Why?
Because it introduces an interesting word. The Chief Justice has the right. Where from that right?
She references this.
Listen, no, she says a Chief Justice had the right to a public hearing. Meanwhile, Article 1467 and 8 says all proceedings, all, no exception. So you read constitutional text as a whole. But where the Constitution itself provides a mechanism for addressing an issue, the judges usually put it back to us. It's a counsel. Where from these rights? Is this right a right recognized under a law? Which law? Mm-hmm. If it's not a right recognized under a law, where from this novelty of now suggesting that in Article 146 proceedings, a Chief Justice has a right to public hearing? That's provocative. Mm-hmm. Completely provocative. Because the Constitution, which is the supreme law of the land, says that all the proceedings, without exception, should be held in camera. So a suggestion that in the specific case of a Chief Justice is one to suggest discrimination. That the Chief Justice is not equal among the other superior court judges or persons who are subject to Article 146, and for that matter, an exception should be created for the Chief Justice or whoever occupies that.
Argument has been made that she's the one who's accused, and she's asking for a public hearing so everybody gets to see what's going on, because already this matter is being tried.
When you give the phone to them, then raises the further question of access. The further question of access. You can also say, I have nothing to hide. And so I am giving you my password. Yes. Or they'll go to court for a search warrant to go into the mobile phone. That's a right. You can waive it. And that's why you can say that I have nothing to hide. And for that matter, I am doing. But there is no right.
So in this case, the relief one, there's no right to be waived.
To be waived. You must first have a right that you can waive. And I'll give you a classic example. I'm really shocked that Godfred is the one putting up this view. In the Atoforsen matter, right? There was a time that he needed to travel also. Then we said, oh, the trial can proceed.
Okay.
In fact, before that, the second accused, Dr. Sylvester Nimena, he was so sick, very sick, that he was coming to court in a wheelchair. Mm-hmm. So we suggested to the court that, is it possible that he should be excused? Once he's on bail, he should be excused from court attendance so that the proceedings can go on. Incidentally, the Attorney General, Godfred Dame, then raised the issue that Article 19, the Fair Trial Rules, say the trial should happen in the presence of the accused person. Mm-hmm. And so to the extent that that would amount to, quote unquote, a waiver of that provision, it offends the Constitution. And that is how come Nimena was coming to court every other day unless he goes for his dialysis. Until the AG himself now decided to do what? A nolle prosequia in respect of that matter. Mm-hmm. So I think we should all come to the conclusion that in the wisdom of the framers of the 1992 Constitution, if they had envisaged that the Chief Justice under Article 146 should be treated differently. They would have provided that exception and not use the word all. The use of the word all means that right from the time the president received the petition to the time when the whole matter ends, all other things must be done in camera. You could have said, oh, when it comes to the hearing itself, an exception should be created so that the it is not a very attractive constitutional proposition to make because of the policy rationale to safeguard the integrity and the dignity of the process itself.
And the persons.
And
Okay,
the persons involved.
I'm bringing Franklin. Could you please stand by on this one and then I'll seek your thoughts. But you see, there's a lot of things at play which may be unprecedented.
Yeah.
I mean, it's the first time we're having a Chief Justice so suspended, being a plaintiff in a case before the Supreme Court where she used to empanel, justices until the time she was suspended. It's unprecedented within our legal jurisprudence, so you can understand how things are playing out now. But then again,
no,
that position
can I read
about,
something? Let me just read something. Let me read something quickly. 30 seconds.
Quickly.
You know, the Ghana Bar Association took Aban. You remember the Aban case?
Yeah, Aban case.
This is what His Lordship Justice Pegan said, and let me just conclude from here. It is clear from the above that under our Constitution 1992, a Chief Justice or a Justice of the Superior Court of Judicature or a Chairman of the Regional Tribunal can only be removed from office by the President, acting on the recommendations of a committee appointed by the President or the Chief Justice, as the case may be, to inquire into a petition sent to the President alleging misbehavior or incompetence against the one concerned, or his inability to perform his functions because of the infirmity. Now, this is what is instructive. It is important to note that Article 1468 of the Constitution, 1992, provides that the proceedings of the committee appointed to deal with said petition shall be held in camera. It is mandatory, said that proceedings be held in private and not in public or open court, as has unfortunately been done in this case. The reason for this important provision is obvious. It is to preserve, protect, safeguard the authority, dignity, and independence of the judiciary. It will be a sad day for this country if this court were to grant the request of the Plaintiff Association and start removing our judges in open court, contrary to the provisions in this. And the Chief Justice and the former Attorney General.
The protection of the sanctity of the process and the people involved. And like Christian Mamhesi, as against this demand by the Chief Justice that, yes, this is the provision of the Constitution clearly stated, but I have a right to waive, and because I want people to get to see on TV how this entire process plays out, so that in the interest of transparency, that everybody would see it, because already this matter is being tried in the court of public opinion. Does that suffice? Yes,
I mean, I start from the case of Ghana Bar Association versus Attorney General. And indeed, the reason, as my learned senior mentioned, is right, that the whole reasoning, the jurisprudence behind that is to preserve the dignity and the judicial independence of the judiciary. And that point has more than necessarily been overflowed. But that is the basic point. Now, I also agree with my learned senior Pebu on the fact that the Constitution definitely ought to respond in the changing times. Because if you look at other constitutionally decided cases, it speaks to the fact that where we have Justice Adade saying that the interpretation of the Constitution, just as my senior said, must reflect the changing times. And the two prongs that impede interpretation I always mention, which was also espoused by Dr. Justice Dr. Ban, that we have the objective test and then the subjective test. The objective test in construction of a constitution deals with the intention of the framers of the constitution. And then the subjective test deals with the changing times, the values, the legal and